Mr. Joshi?
Mr. Chief Justice, and may it please the Court, I think if you look at the phrase with respect to motor vehicles in isolation, Petitioner has a pretty good point about how to interpret just those words in isolation. But I don't think it works in this statute, and I really focus on the contrast between paragraphs 1 and 2. Paragraph 1 uses the phrase with respect to the transportation of property. Paragraph 2 with respect to motor vehicles. That seems like a conscious choice that Congress made to parallel the language but change the noun to a much narrower noun. As Mr. Clement observed, transportation has like 24 or 25 different nouns, I think I counted, one of which is motor vehicles. So that suggests that with respect to motor vehicles must not include things that are with respect to the other stuff in the definition of transportation, one of which is arranging for the movement of property, which is what a broker does. Put it this way. Suppose there were a rule that applied with respect to coffee, cream, and sugar, and then an exception that applied only with respect to coffee. You would naturally think that the exception does not apply with respect to cream and sugar, even though that phrase in isolation might cause you to adopt the opposite view. I think that's kind of what's going on here, and that's why I think Respondent's reading of the statute is the better one. I welcome the Court's questions.
Is there any daylight between your argument and that of the Respondent?
I don't think so. I think we're aligned on the interpretation of the safety
with respect to the use or the role of brokers, how significantly has that increased?
I agree with what Mr. Boutros said. It has increased markedly before the deregulation. There were only several hundred brokers, is my understanding. Today, there are approximately 25,000 federally registered brokers operating, from small sizes to as large as C.H. Robinson.
What role did the ICC play in regulating transportation in intrastate before deregulation?
I don't know exactly the extent of the role. My understanding is that they generally would have thought that intrastate regulation has a substantial effect on interstate commerce, and so to the extent there would be inconsistent rules, as both Mr. Clement and Mr. Boutros mentioned, the Castle case is from the 1960s, I think, and that really exemplifies these things. Illinois there had certain regulations for trucks, but this Court said that Illinois cannot use a violation of those in order to revoke the operating authority, even for the intrastate trucks.